Good morning, everyone. Today I will be addressing a crucial concept under the Insolvency and Bankruptcy Code 2016, the meaning and scope of security interest, particularly in light of clarificatory explanation inserted by IBC Amendment 2026, which restricts its ambit. This issue is not merely academic. It directly impacts the distribution of proceeds under insolvency and liquidation. Good morning. Let me begin with a statutory framework. Section 3, subsection 31 of the code defines security interest in broad terms. It includes any right, title, interest, or claim to property created in favor of a secured creditor and covers instruments such as mortgages, charges, hypothecation, and assignments. However, the explanation appended to this definition introduces an important limitation. It clarifies that a security interest exists only when it is created pursuant to an agreement or arrangement between two or more parties, and specifically excludes any interest that arises merely by operation of law. In essence, the code recognizes only those security interests which are contractual and consensual in nature. It does not extend the same status to rights that arises automatically under the statutory provisions. To understand this better, let us examine the essential elements of a valid security interest. First, there must be an arrangement or agreement. This means there must be a conscious act of parties entering into a transaction, such as a loan agreement accompanied by a mortgage or hypothecation. Second, there must be at least two parties, typically a creditor and a debtor. Third, the arrangement must create a liability enforceable right in a specific property. This could include the right to take possession, enforce sale, or otherwise realize the secured assets in case of default. If any of these elements are missing, the claim may not qualify as a security interest under the code. Now, equally important is understanding what is excluded. The explanation makes it clear that interests created merely by operation of law are not covered. This includes statutory dues such as taxes, government levies, provident fund dues, and similar obligations. At this stage, it is useful to refer to judicial developments. In the case of State Tax Officer versus Rainbow Papers Limited, the Supreme Court held that statutory dues under certain VAT laws which create a first charge on property could be treated as secured debt. This decision created considerable uncertainty as it appeared to elevate government dues to the status of secured creditors. However, this position was subsequently clarified in Paschimanchal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited. The court emphasized that government dues do not automatically become secured debt. For such classification, there must be a clear statutory provision creating a charge on a specific property. Further, in Ghanashyam, Mishra and Sons versus Edelweiss Asset Reconstruction Company, the Supreme Court held that once a resolution plan is approved, all statutory dues not included in the plan is termed extinguished. This reinforces the principle that statutory authorities are generally treated as operational creditors. Now let us briefly touch upon the practical implications. First, in the constitution of the Committee of Creditors, all financial creditors, whether secured or unsecured, are included, provided they qualify under Section 5, subsection 7 and Section 5, subsection 8 of the Code. Security interest is not a precondition for participation or voting in the COC. However, operational creditors, including most statutory authorities, do not form part of the COC. Second, under the waterfall mechanism in Section 53, secured creditors rank significantly higher than government dues, which are placed lower in priority. Third, for insolvency professionals, this distinction is critical while verifying claims. It is essential to examine whether the claimant has a contractual basis, whether the charge is properly documented, unregistered, and whether it is linked to a specific asset. Misclassification at this stage can materially affect the entire resolution process. Understanding and correctly applying this distinction is essential for effective insolvency practice. Thank you for watching. This is CA and IP Praveen Agrawal signing off. See you in the next presentation. Thank you.